Today, a district court struck down California's ban on large capacity magazines. We think the court got this decision dead wrong, and my office is immediately filing an appeal.
So Judge Benitez has issued his ruling, which found that California's magazine ban is indeed unconstitutional, and therefore he has entered an injunction. So let's get into what's going on. But real quick before we jump into this video, if you think magazine bans are clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I'm gonna give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for 2A organizations, so if you want good coffee and you want to support the 2A cause, purchasing Blackout Coffee is an amazing way to do that. You can find them using the links down below, and if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we're going to be breaking down the decision that was issued by Judge Benitez yesterday in the Duncan v. Bonta case. In Duncan v. Bonta, he recently issued a ruling which struck down California's ban on so-called large capacity magazines. California Penal Code Section 32310 bans the buying, selling, possession, etc. of magazines that hold more than 10 rounds. This law was challenged in a district court, and Judge Roger T. Benitez, or St. Benitez, issued his original order finding that the law was indeed a violation of the Second Amendment. That then led to what is known as Freedom Week in the state of California. After the state of California lost that original preliminary injunction, they then appealed that decision up to the Ninth Circuit. Then the case was sent to the Ninth Circuit en banc panel for an appeal, and on review, that Ninth Circuit en banc panel ruled in favor of the state of California. That decision by the en banc panel was then appealed up to the Supreme Court, and the Duncan case then was put on hold at the Supreme Court level and was waiting for a different case to be ruled on, and that was the New York State Rifle and Pistol Association versus Bruin case. What they ended up doing is granting, vacating, and remanding the Duncan case back down to the Ninth Circuit. Now, the Ninth Circuit didn't want to address this issue originally, so then they sent it all the way back down to Judge Benitez for him to redecide the case in light of Bruin. Well, yesterday, on the Attorney General Rob Bonta's birthday, Judge Benitez released his decision in Duncan. And ultimately, Judge Benitez once again ruled that California's magazine ban is a violation of the Second Amendment. It's a violation of the text and history of the Second Amendment, and therefore he issued an order to prevent it from being enforced any further. He put an injunction against this California magazine ban. Now, in that same order, he also granted a 10-day stay on his own order, which means it will not go into effect until October 2nd. In that order, he issued the stay so that California could seek an appeal and also a stay of the decision from the Ninth Circuit. And in fact, California last night, already filed a notice of an appeal up to the Ninth Circuit. Now, that's not surprising because every other Pro-2A win and every other Pro-2A case that we've got, California did the exact same thing. They appeal up to the Ninth Circuit, they seek a stay, and then they try to get any positive ruling to be halted. Now, in the decision, Judge Benitez states that the state argues that larger capacity magazines are not arms. First, the state argues that magazines are not essential to the use of firearms and consequently would have been thought of as accessories. But magazines are integral components to vast categories of guns. While the Second Amendment does not explicitly mention ammunition or magazines supplying ammunition without bullets, the right to bear arms would be meaningless. This is because the right to keep firearms for protection implies a corresponding right to obtain the bullets necessary to use them. The possession of arms also implied the possession of ammunition. By extension, arms includes the magazine component necessary to supply the bullet into the chamber of the gun. Put more broadly, he states, the Second Amendment protects ancillary rights necessary to the realization of the core right to possess a firearm for self-defense. Consequently, whether thought of as a firearm able to fire a certain number of rounds because of its inserted magazine, or as a separate ammunition feeding component, magazines are usable arms within the meaning of the Second Amendment. He then goes on to tear down California's argument that magazines that hold 10 or less rounds may be protected arms, but a magazine that holds 11 or more all of a sudden magically is no longer a protected arm, and then the state can regulate or ban them however they want. Benitez responds to this argument by the state of California by saying that what the state seems to be really saying is that a magazine may be a protected arm, but only the state has the right to pick the number of rounds a citizen may have in his gun. He goes on to say this court disagrees. The Supreme Court has not described protected arms in subdivided categories. Then there was a very interesting section where Judge Benitez used California's handgun roster laws actually against them to completely shoot down the concept that magazines are not necessary for the operation of a firearm. California tried to argue that magazines are not necessary for certain handguns to fire. He points out that at least when it comes to semi-automatic handguns, the roster requires that a magazine disconnect needs to be put in place, which ultimately prevents even a chambered round from being fired if a magazine is not inserted. Therefore, under California's own laws, they show that magazines are absolutely necessary for the operation of some handguns, especially under these state restrictions. He then goes on to destroy the state's argument that magazines are not actually used for self-defense. The state tried to argue that actual use is what is needed, not just simply ownership and the intent to use them for self-defense. Now, in response to this, Judge Benitez states in the opinion that it is a remarkable reading of Heller, McDonald, Caetano, and Bruin to say that if a gun is not fired more than 10 times in self-defense, then the gun's larger magazine is not being used in self-defense, and if not used in self-defense, then it's not protected by the Second Amendment. Yet this is the state's theme. In this court's view, it is a crabbed reading of the Supreme Court's Second Amendment decisions and not relevant to the text, history, and tradition test. The Supreme Court has not said that the actual firing of a gun is any part of the test. Indeed, the Second Amendment does not say that the right of the people to keep only such firearms as they actually shoot shall not be infringed. So this is pretty much just a masterclass of how to just completely shoot down all the absurd anti-gun arguments and legal arguments that they're now making in response to the Supreme Court's Bruin decision. He then calls out California for trying to change the dangerous and unusual test. He states that taking another tack, the state reframes the dangerous and unusual test as dangerous or unusual test, and then objects that magazines able to hold more than 10 rounds are unusually dangerous. As the court has stated, all guns and ammunition are dangerous. However, magazines holding more than 10 rounds are not both dangerous and unusual, which is the Supreme Court test. So there he's calling out California for trying to change some of the language. He then goes on to reject the new historical evidence presented by the state of California in light of Bruin. He points out that most of the historical arguments were rejected by him prior to the Bruin decision, but then he gave them ample time to come up with additional new arguments in light of Bruin to go back to 1791 and try to find some historical arguments. And he found that pretty much none of those arguments were convincing at all. California put forward about 38 racist laws as support for the magazine ban, but Benitez said that those laws are not relevant at all. Then he also goes on to reject what the state of California claims is their best argument. California claims that the New York City gunpowder storage law, which was the 1784 law, that they claim it justifies the magazine ban that they've put in place. But Judge Benitez rejects that analog since that law had nothing to do with firearm safety, it had nothing to do with gun control, but instead it was just simply a fire safety regulation. It wanted to do something to prevent future fires from taking place, but it's not an appropriate analog for what the state of California is trying to do with their magazine ban. And based on all that, Judge Benitez found that California's magazine ban was indeed unconstitutional, and he granted the injunction. Again, it will not go into effect for 10 days, and California has already appealed this up to the Ninth Circuit. They've already submitted the notice of an appeal. Now, again, I know some people are still going to ask me, okay, all of that's interesting, but can I go out and buy magazines right now? I want to buy magazines. What can I do? The answer to that is no. Right now, you cannot go out and buy magazines that hold more than 10 rounds. The ban is still in place. Best case scenario is that October 2nd, when the stay is lifted by Judge Benitez, maybe then you could purchase magazines. That's best case scenario, but I wouldn't hold your breath for that type of situation. The likelihood is that the Ninth Circuit will grant an appeal, and they will also grant a stay to the state of California. It's still a huge decision. We have something heading in the right direction. This is going to impact other states like Washington and Oregon going forward because it's going to go to the Ninth Circuit, but we will have to see how this plays out. And if I get any more information, of course, I'm going to let you guys know. So if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.